Hello everyone, my name is Aaron Morris, and I'm going to be discussing in this case brief the case Parents, individually and as parents and legal guardians of XX, a minor, versus Lewiston School Department. It's hearing number 15.060X. Here is the link to the case, and it occurred from June 9th and 10th. 2015. The facts of the case. There was a lot of facts, specifically in regards to the student and the history of the student, the disability, history of the student prior to coming to the current school department. To boil them down, the student had a long history of demonstrating aggression, hyperactivity, and impulsivity. Been diagnosed with ADHD, OCD, ODD, at least 15 or 20 medications with dysregulation of the dosages, resulting in further behavioral issues. The parents, who are listed as bringing the case forward, adopted the student. The student's biological parents had a lot of problems, histories. Prior to attending the Farwell Elementary School of the Lewiston School Department, the student attended CDS, had an IEP centered around behavioral issues, and the services ended a few months prior to the student moving on to elementary school because the student's IEP goals were met. So that fall, the student began attending Farwell Elementary School. Due to increasing behavioral issues, on October, same year, a 504 meeting was held with a plan developed for the student. Due to more frequent and severe behavioral issues at home and school, the parent initiated a special education referral on March 24th, 2015, spring of the same first year of elementary school. The relevant dates. And these dates are all relevant in regards to what we're going to see later on in this case. So I'm going to go through the dates, and these have actually been whittled down somewhat. So March 24th, like the previous slide said, was the date that the parent initiated a meeting and shared with staff that earlier that morning, the student had an incident that resulted in harm to animals at the home. The school terminated the IEP meeting and very strongly suggested that the parent take the student to St. Mary's for crisis intervention, St. Mary's Hospital. The parent took the student to St. Mary's Hospital for crisis intervention. A couple days later, on March 27th, the parent consented to a risk assessment. The school issued a letter stating that the student, quote, will be suspended from school until a risk assessment is completed. A couple days later, on March 31st, the student was discharged from St. Mary's after 8 days of inpatient services. The next day, April 1st, the risk assessment was initiated. The next day, on April 2nd, there was an IEP meeting, and the staff recommended that the student receive tutoring for 2 hours daily at Renaissance School beginning on April 23rd, while special education evaluations were completed. The parent disagreed with the recommended placement, but the parent signed the consent for release of information of records from the school department to Renaissance School. The parent informed the school that the family would then be taking a vacation. And from April 9th through April 19th, the family was on a family-initiated vacation. April 20th through the 24th, the school department was on spring break. That's Monday through Friday. Monday the 20th through Friday the 24th. And on April the 27th, which would be the following Monday, the parent toured Renaissance School and then the parent contacted the Lewiston School Department and refused for the student to attend Renaissance School, stated they would tutor the student at home, and the school provided daily work for the parent. As of May 14th, the parent filed this expedited due process request, and the student had not returned to school as of the date of the hearing. The issue: was the student subjected to a change in placement within the meaning of 34 CFR 300.536 and in violation of 34 CFR 300.530 and 5.531? Holding. So the due process hearing ordered that the student was not subject to a change in placement within the meaning of 34 CFR 300.536, thereby disagreeing with the parent's position that the school department removed the student from his regular such and such grade classroom as a matter of discipline for behavioral incidents in violation of the school's code of conduct. The parent asserted that the removal constituted a change of placement in violation of procedural protections of the IDEA, specifically 300.530, 0.531, 356. I'm sorry, 0.350, 351, and 356. And they said that there was no parental consent given for that change in placement. The rationale for the decision, excuse me, was that the hearing officer found that the parents, well, this part was a little confusing to me. So there was a huge rationale that came out of the decision itself. And this first part, I think, is a standard part of going through one of these hearings in regards to who's the burden of proof on. The hearing officer found that the parents bore the burden of proof, and there was this Schaefer versus Wiest citation in regards to that. And this was found that although the student was not under an IEP, but instead a 504 plan, the student had a long history of behavioral issues, and the parents initiated a special education referral. Thus, the student is entitled to the protections under 300.354. What I think that means is that the child does fall under IDEA, and because the child falls under IDEA, that it's the parents who have the burden of proof in regards to the aspect of the regulation that's currently being discussed. A summary of the hearing officer's analysis, and I underlined the relevant sections. So the first point that the hearing officer wrote was, the threshold question to be answered in the analysis is whether the student's removal from the school constituted a change in placement within the meaning of this section. And then they list the section. So is it a change in placement? There was significant testimony, and this is me consolidating that, regarding whether the student was removed for disciplinary reasons. The officer discussed the student's behavior and their gravity. That letter that I previously mentioned, where they said that the student, I don't know if it's he or not, but the student was suspended. That was a form letter, and there wasn't a lot of weight put behind the letter itself by the hearing officer. And there was no disciplinary documentation created by the school, and the school personnel's testimony was very caring in nature, and they really wanted to make an effort in regards to the follow-up of the student. They were visiting the student in the hospital. It was it wasn't seemingly like a hands-off decision that was made. It seemed like the IEP team was very involved in the students' well-being. Now, that being said, the officer found that 300.536 applies to this case no matter which side of the disciplinary coin a party positions itself. This was found even though the school department disagreed that discipline motivated the student's removal. The fact remains that behaviors and conduct demonstrated by the student triggered this entire chain of events. So, the student was removed, is what the hearing officer is saying, and it was because of behavior. And even though it may not have been done for disciplinary so-called purposes, it's still 300.536 applies. The analysis point 2, though, is that the officer wrote that the second question regarding the initial threshold question is the requirement that a change of placement occurs only if it is for more than 10 consecutive school days. Was the student removed for greater than 10 days? The parent maintains that the student's removal from school commenced on March 27th, and the parent had a lengthy argument regarding crisis services, Renaissance, school, letters, dates, appropriateness of services. And the school department argued that it could not be responsible for the ticking away of days school was in session, but parents and the student were on vacation. The hearing officer agreed with the school. The student did not access educational services because of the family's planned vacation, not because of the school department's recommended placement at Renaissance School. So therefore, it got rid of all these days counting toward the 10-day removal period. And furthermore, the 5 days, Monday through Friday, of school vacation are not school days on the school calendar. So those 5 days do not contribute to the accumulation of 10 consecutive school days. So the student was removed, was not removed from his current educational placement for more than 10 consecutive school days. Hence, a change in placement under 300.356 did not occur. So just to kind of go back, so the first point, a removal did take place. It was because of behavior, and it doesn't really matter if it was for disciplinary actions. It happened no matter what. But the second point is, was it for more than 10 consecutive school days? No, it wasn't. So because the student was not removed from his current educational placement for greater than 10 consecutive school days, for all practical purposes, the analysis of the issue that was being brought forth was moot. Because school personnel under this section may remove a child with a disability who violates a code of student conduct from his or her current placement to an appropriate alternative educational setting, another setting, or suspension for not more than 10 consecutive school days, and it wasn't for more than 10 consecutive school days. Further analysis, the parents also had brought forth, I'm not really sure this applies, but I added it in. They said that there was no manifestation determination, but the school department was not obligated to conduct a manifestation determination because it wasn't for greater than 10 school days. And then they said that no functional behavioral analysis took place. Again, they didn't have to do it because they weren't required to do it because it didn't go over more than 10 consecutive school days. And these two things are things that a school would have to initiate in order upon removing a student for greater than 10 school days. So that is the case brief. My critical thinking question was, how would this due process hearing case's outcome or arguments change if the family had left on their family vacation on Saturday, April 11th, instead of first thing in the morning on Thursday, April 9th, 2015. So if they had left 2 full days earlier, what would have happened during this hearing? Thank you, everyone. Have a good day.